event, recent developments in Massachusetts case law. Our speaker today is never late, but never arrives early. In fact, this is his first time he's come in within 30 seconds of the start time, and it's always like the mother of the bride wondering whether the groom is going to come to the church on time. Phil Payton has been doing this for longer than most of you can remember. He's a partner at Holland and Knight. He'll be speaking shortly. Massachusetts Attorneys Title Group, a generous sponsor of this conference room. Materials provided by this company can be found on the table directly outside the breakout room. Phil's materials are on 243, page 243 of the syllabus. This session is approved for 60 minutes of general CLE credit in Rhode Island. As most of you have probably heard multiple times by now, New Hampshire no longer offers formal CLE credits. It's a self-certification system, but you still have to sign the sheet at the back, and you'll get one credit. I welcome Phil.
Thank you very much, Peter. Let me begin today by commending the perseverance of those of you who continue to handle residential mortgage loans in the face of so many obstacles. I used to do them. I once had to draft a truth in lending statement out of whole cloth because it was a balloon note. And back in those days, they didn't have a standard form, so I was very proud of myself. I did a 2-page form that would tell the borrower everything he needed to know. About 3 months later, I got fined $500 because it's all supposed to be on one page. So that was the end of that. Anyway, the biggest problem, of course, that you face nowadays is probably the new federal Consumer Financial Protection Bureau, a boogeyman which was created to protect consumers from unfair lending practices. Now, the CFPB has warned lenders that they can be held responsible if their vendors, including closing attorneys, don't have adequate safeguards in place to prevent identity theft. In fact, a recent article in Banker and Tradesman predicted that lenders will respond to this warning by dramatically reducing the number of firms which qualify to handle their loans. Now, personally, I've never been too concerned about identity theft. If somebody wants to assume my credit card debt and support my brother-in-law, they're welcome to my identity. Then there's the new 2,000-page set of CFPB regulations, which become effective in August and require settlement statements to be in the hands of the borrower 3 days in advance of the closing. And to add insult to injury, the agency gave its rule a cutesy name: know before you owe. Now, I mean, really, what's next? Maybe you'll need to get a disclosure form 3 days before you buy a saxophone, know before you blow, or 3 days before you take a vacation or a laxative, know before you go. Or 3 days before a man takes prostate medication, know before you flow. Or 3 days before a woman takes fertility drugs, know before you grow. Well, my own slogan has always been that you need to learn before you earn, so let's take a look at what's been going on in the courts. The appeals court ventured into the world of adverse possession in 1148 Davall Street, where it was clear that the claimant had exercised actual, open, notorious, and exclusive use of a strip of land in Fall River for more than 32 years. So what was the issue? During the first 14 of those years, the record owner of the property happened to be the city itself. And the question was whether or not that time ought to be disregarded. Now, it is true that a 1987 enactment prohibits the use of adverse possession to acquire any land which is held for a public purpose. But the court included those 14 years anyhow, holding that the statute is irrelevant unless the property is currently owned by a government body. In Matthews, another municipality, namely the town of Tisbury, was the claimant, seeking to establish a prescriptive easement for public use of a dirt pathway. The effort failed in the absence of any evidence that town officials themselves had ever exercised any dominion or control over that land. In fact, the only public employees who regularly made use of it were mail carriers, who of course work for the federal government. In Giambetti and Long, the land court had no problem recognizing prescriptive easements to make use of driveways which encroached onto a neighbor's property. Now, that wasn't enough to satisfy the claimant in Giambetti, who also wanted his neighbor's hedges. But Judge Grossman refused to go along, noting that the claimant had trimmed and otherwise maintained the hedges only on a sporadic basis. Now, a prescriptive easement was established in Lazarus to make use of a private way in Easton for purposes which included driving to a beach, parking a car, and storing a boat. Page was another case in which somebody was asserting a prescriptive easement to make use of a passageway leading to a beach. This time, however, that use had originated many years ago as a friendly accommodation between the neighbors who at that time owned the property. Now, even though the current neighbors were undoubtedly very hostile to each other, their battle had been ongoing for less than the 20 years which is needed in order to validate adverse possession. There was no question in Owens that a claimant had succeeded in obtaining adverse possession of a strip of land adjoining his house in Abington. In addition to building a storage shed and using the area for any number of activities, including gardening, cutting firewood, and picking blueberries, he had also buried Duke, the family dog, there. Who would want the property back after that? An important issue of statutory construction was addressed by the appeals court in Drummerboy, which kicks off our list of condominium cases. When a unit owner failed to pay monthly common charges, the managing board brought suit to recover the arrearage and establish a lien. Now, according to Chapter 183A, that lien is supposed to enjoy priority over the unit owner's mortgage to the extent of any common charges payable during the preceding 6-month period. Well, when the unit owner failed to bring his account current, and in fact his debt continued to grow, the association filed 2 more actions, essentially attempting to extend the priority period. The court rejected this ploy, explaining that the 6-month limitation would be rendered superfluous if successive lawsuits could be utilized to secure the entirety of a unit owner's delinquency. In Sewell Marshall, 2 adjoining condominiums in Brookline had been created by the same developer, a guy named Roger Stern, who Bob Galvin and I know very well. Pursuant to authorizing provisions in the master deed and the bylaws, the 2 managing boards agreed with each other to combine their parking areas into one lot, which would be jointly administered. Now, even though this was more than a bit unorthodox, the land court upheld the arrangement, which had been in effect for approximately 35 years before anyone saw fit to raise an objection. Our only other official condominium case, overlooking, as we usually do, those unpublished appeals court decisions, although I will make a couple of exceptions later on, was Wadinsky, a high-stakes struggle between wealthy unit owners which captivated the media. The battleground was a 5-unit building at 303 Com Ave in Boston. The owner of 4 of the 5 units was desperate to acquire the 5th in order to create a single-family residence. Of all the pressure tactics which were utilized to gain control, the most egregious by far was getting the Department of Public Safety to shut down the elevator, forcing the other unit owner, who, by the way, happened to be 84 years old, and his 68-year-old wife to navigate the 86 steps which separated their unit from the street. The court found ample evidence from which the jury could reasonably have concluded that illegal coercion, intimidation, and threats justified the imposition of hefty damages. Our first easement decision is Casey, where the Archdiocese of Boston operated a school which benefited from an easement providing a secondary means of travel along the rear of the parcel. Now, in order to make sure that students didn't wander off, the church erected a fence, making it impossible to access the right-of-way from the school. Well, that strategy might have succeeded, but it came at a cost. The land court decided that the easement had, in fact, been abandoned. Now, whether a railroad easement had been abandoned could not be addressed by the land court in Murray, given that such a determination may be made only by the Federal Surface Transportation Board or the U.S. Court of Appeals. Easements can also be extinguished if they become impossible to enjoy. Now, that was the allegation which was made in the Rigo case. The easement was supposed to provide access to a beach in Brewster, but that area had been designated by the Division of Fisheries and Wildlife as a priority habitat, the disturbance of which was prohibited in order to protect the spotted salamander. However, even though it might no longer be possible to trample over that area, the land court held that the easement had not been destroyed, given the possibility of constructing an elevated boardwalk. Now, easements by necessity typically arise where you get a access easement over the grantor's remaining land because you've bought a landlocked parcel that would otherwise be inaccessible. What you need to remember today is that an easement by necessity, contrary to what you may have thought, does not arise as a matter of law, but rather requires some evidence that the grantor was in fact willing to accommodate the grantee's need for access. In Kittredge, which we've talked about so many times as it worked its way through the judicial system, the appeals court concluded that the conveyance of several landlocked parcels as part of a distribution to the members of the Wampanoag tribe in the 19th century was subject to an Indian custom which generally allowed unrestricted travel over and across the various lots. Accordingly, based on that custom, an easement by necessity had been created and continued to the present day. Now, Justice Agnes strongly dissented. In fact, his opinion was longer than the majority opinion. He basically took the position, interestingly enough, that the existence of the custom, in fact, made the easement unnecessary. But again, he was in the minority. In Perry, meanwhile, the grantee of a landlocked parcel pursuant to a 1913 deed had been given a utility easement over the grantor's remaining property. Given the conveyancing principle that a deed's express grant of one easement is meant to exclude all others, the land court held that the grantor had intentionally and deliberately refused to allow the use of his land as a means of access, meaning that no easement by necessity had ever been created. Now, do keep in mind, if these kinds of cases alarm you, that they're really nothing more than historical curiosities. They all date back to the day before the subdivision control law was enacted, and nowadays, of course, no planning board would allow the creation of a landlocked parcel without adequate access. A variation on the theme was offered in Topeka, where a grantee had in fact obtained an express easement to cross the grantor's lot for access and utility installation. But he wasn't satisfied. He asked the land court to let him use an alternative route, which was more to his liking, but Judge Foster predictably refused. That brings us to eminent domain, where we find a case arising from the taking in 2001 of a 5-acre parcel which was needed for the construction of a new elevated ramp to Gillette Stadium. The trial judge decided that damages could not include the potential use of that site as a hotel, which was disallowed under the then version of the Foxborough zoning code. But in Rodman, the appeals court disagreed, explaining that the former owner should have been given a chance to demonstrate that he could have obtained relief from the Board of Appeals. In Swan, somebody acquired property which was bisected by a strip of land owned by a third party. The land court was of the view that before taking title, that buyer and any self-respecting conveyancer representing that buyer should have investigated the ownership of that strip. Had they done so, they would have determined that the strip had previously been taken by eminent domain by the MBTA. Therefore, the time period within which the buyer could have challenged the taking commenced to run on the date of the closing and had passed before the suit was commenced. Now, what's amazing about all of this is that it was all dicta, and I'm not sure why the judge went to all the trouble of offering that analysis, because his additional conclusion was that only the owner at the time of the taking, not a subsequent buyer, has standing to contest the validity of the taking or to seek damages. Now, the old adage that you can't fight City Hall was very much at the heart of today's 4 land use cases, all of which left defeated plaintiffs licking their wounds. In Janes, a property owner complained to the land court after being required by the Groton Board of Health to abandon his septic system and instead connect to the municipal sewer. The court declined the invitation to intervene, noting that its limited jurisdiction could not be stretched to include a case like this, which does not implicate any right, title, or interest in land. In Junior, somebody needed to get a permit from the Marshfield Conservation Commission in order to fill a freshwater wetland. The permit was issued subject to several conditions which needed to be satisfied within 3 years. Because the land in question was registered, the permit was duly noted on the certificate of title as required by the applicable statute. Now get this. Once the 3 years had run, the owner took the position that the permit had expired and therefore should be removed from the certificate, even though the various conditions had not yet been met. You will not be surprised to learn that Judge Long disagreed, describing the owner's position as, and I quote, completely illogical. Not just illogical, but completely illogical. The title will remain encumbered, and the owner will probably face regulatory sanctions to boot. In Nahas, the Seekonk Water District had unsuccessfully bid to acquire a 10-acre parcel of land, which was instead conveyed to a developer. When the district proceeded to oppose the project, the developer shot back and argued that he had been deprived of his rights under the federal Constitution. A federal judge was willing to concede that the district may have been a bit vindictive, but there was still no cause of action in the absence of any showing that the developer had been subjected to governmental misconduct, which could truly be described as outrageous, uncivilized, and intolerable, which is essentially the standard. You may recall the devastating tornado which struck Springfield back in 2011. One building which did not suffer significant damage was nevertheless quickly demolished by city officials. Now, once again, an attempt was made to seek redress under the federal Constitution, and once again the owner was sent home empty-handed. In South Commons, the U.S. Court of Appeals invited him instead to pursue damages under state law where adequate remedies were available. We have 3 official cases on leases today, all of which involve residential tenants. There's a state statute which gives such tenants certain rights to recover attorney's fees if they prevail in litigation with their landlord, but the appeals court held in Avixis that the law could not be utilized by the tenant's father, who had guaranteed the lease and who had to hire a lawyer when the landlord sued him for some damage to the building, which turned out not to have been the son's fault. In Huang, the same court decided that a property manager, not just a landlord, can be held criminally liable for not installing smoke detectors in an illegal basement apartment where a father and both of his sons died from burns and smoke inhalation following a fire. That manager is now doing 2 to 3 years in state prison. The appeals court also decided the third case, involving tenants who believed they had a legal right to cancel a 1-year lease after only 4 months. These were Chinese nationals who had rented a house in Belmont primarily for the purpose of being able to send their kids to school there. Now, while waiting for classes to start, the family went back to China for a vacation, only to later learn that they would be unable to re-enter the United States. You see, the wife had originally obtained a visa to come here for purposes of staffing her company's local office, but she violated the terms of her admission by staying home to take care of the kids. Stranded in China, she notified the landlord by email that the lease was being terminated, but the appeals court refused to oblige, holding that the doctrine of frustration of purpose has no applicability in a case like this where the wife had been at fault and knew the risk that she was taking by leaving the country. Those tenants did eventually find their way back to the United States, where they were hit by a lawsuit and forced to cover the landlord's losses. Borrowers seeking to challenge foreclosures are once again the primary focus of recent mortgage litigation, but I'm glad to report that the number of cases continues to dwindle. From a procedural perspective, the SJC resolved the hotly debated issue, at least hotly debated within this room, of whether a borrower can attack a foreclosure through the so-called tri-title statute, which says that if your property is subject to an adverse claim, you can ask that the claimant, in this case the mortgage lender, be summoned into court and forced to prove that it has a valid interest. Why anybody would do that instead of just utilizing the declaratory judgment statute continues to be something which puzzles me. But in any event, Justice Hines wrote that a mortgagor and mortgagee may be considered adverse parties for purposes of the statute only where a foreclosure has actually occurred, at which point the borrower can request that the lender be forced to defend the validity of its action. On the merits, by the way, the court agreed with the lender that this particular mortgage had been validly assigned prior to the foreclosure, therefore the Ibanez doctrine was of no application. As a general proposition, as we saw once again in Shaw, borrowers have no right to privately enforce federal regulations obligating banks in certain circumstances to negotiate or renegotiate modifications of troubled loans. Nevertheless, those lenders may be subject to sanctions where special circumstances warrant. For example, in Brown and Hanrahan, the lenders falsely asserted that they had never received financial statements and other information which had been submitted by the borrower, in one case on several occasions. The bank in Brown actually had the gall to propose a modification under which the borrower's monthly payments would be higher than they were prior to the default. An additional basis for liability was simple breach of contract, given that the bank had promised to modify the loan so long as the borrower satisfied certain enumerated conditions. The lender in Foley was likewise to blame for having failed to follow the procedures which it had agreed to as part of a class action settlement agreement. Now, it goes without saying that a borrower will have no recourse if he gets a modification but doesn't live up to its terms. That's what happened in Kurtz, where the borrower had failed to complete the necessary application and establish that her income was sufficient to afford the reduced debt service payments. Also, once a loan has actually been modified, Bulmer teaches us that the borrower cannot attack that forbearance agreement on the basis that its terms were not financially feasible. In Biltcliffe, a borrower made partial payments while attempting to obtain a loan modification. After the modification was denied, the borrower brought suit to recover those payments, taking the position that the lender had been unjustly enriched. The U.S. Court of Appeals thought otherwise, failing to comprehend how the lender had done anything wrong by receiving less money than it was actually owed. Another issue in that Bulmer case I mentioned a couple minutes ago related to Chapter 244, Section 35A of the General Laws, which, as you should know by now, describes a detailed form of default notice which needs to be given to residential borrowers. In this particular instance, the notice recited an incorrect loan balance, probably the most fundamental mistake of them all, and that was a deficiency which would need to be corrected before a foreclosure could take place. On the other hand, even though the notice is supposed to identify the quote-unquote mortgagee, The appeals court held in Haskins that it was sufficient to name the servicer of the loan to whom payments were made and with whom the borrower typically corresponded. This was nothing more than harmless error. Now, the fact that a borrower allegedly did not receive the default notice did not matter in Goulet, and that's because the statute requires nothing more than proof that the notice was sent by the lender. Shea is the latest in a series of cases validating the way mortgage electronic registration systems does business. In essence, MERS holds legal title to mortgaged property in trust while the note is transferred among MERS's member institutions. The appeals court held that these mortgages can be assigned, at least as a matter of real estate law, without the necessity of proving that MERS had obtained possession of the note or the express authorization of the note holder to transfer the mortgage. Even though Chapter 183, Section 6D of the general laws requires every residential mortgage assignment to include the names of the mortgage broker and the loan originator, the legislature was kind enough to add that violation of that law does not affect the validity of the assignment, as the land court noted in Zullo. As part of the same opinion, the court also added that the assignment does not need to include a recitation of consideration, and also that the eventual foreclosure of the mortgage was not affected by the lender's failure to comply with the Service Members Civil Relief Act because the borrower was not actually in the armed forces. The bankruptcy court has not hesitated to expunge mortgages which fail to contain appropriate acknowledgments. But Judge O'Toole, God bless him, showed some mercy in the first of today's Bank of America cases. The borrower's name had been omitted from the notary's certificate, but that defect was cured by an affidavit which was recorded before the borrower went bankrupt. There was no such affidavit in Mabazira, where the mortgage was invalidated even though it had been accepted for registration. It was good enough for the land court, but not the bankruptcy court. In Tebow, the borrower's name was misspelled in the mortgage, but it made no difference because the same misspelling appeared in the deed under which she had previously acquired title to the property. A mistake of a different kind was made in O'Connell, where the mortgage failed to include certain additional lots which were part of the borrower's property. The land court found that both parties had intended the entire property to be collateral for the loan, and the mortgage was reformed accordingly. There are various nonprofit organizations out there whose mission in life is to purchase homes which have been acquired by lenders via foreclosure but are still occupied by the borrower. The borrower is then given an opportunity, after the nonprofit organization takes title, to keep his family in the house by paying rent to the nonprofit. Some vindictive lenders have sold these houses subject to an express condition prohibiting future occupancy by the original borrower. The Massachusetts legislature outlawed those kind of agreements in 2012, but a federal district court judge held in Commonwealth that the statute could not be enforced against Fannie Mae or Freddie Mac thanks to some preemptive federal regulations. Preemption of a different sort dictated the outcome in East Hampton Savings Bank, involving an attempt by the city of Springfield to regulate foreclosing lenders by requiring them to remove hazardous waste and comply with various standards related to health and safety standards, guidelines rather, which were outlined in the ordinance. The SJC held that the ordinance was preempted, first of all, by Chapter 21 of the General Laws, which comprehensively governs environmental remediation at a state level, and also by the state sanitary code, which establishes what are supposed to be uniform standards of habitability. The city did win a consolation prize. It was allowed to continue to impose registration fees on foreclosing lenders in order to fund the cost of inspecting and securing these properties. Equitable subrogation is the doctrine under which the refinancing of an existing first mortgage allows the new bank to inherit priority over an intervening lien of one kind or another which had not been discovered by the closing attorney. The land court applied the doctrine in Bank of America versus Miranda, but it refused to do so in U.S. Bank, where the intervening lien, which happened to be another mortgage, had already been sold to a bona fide investor who had no knowledge of the subrogation claim. Today's only purchase contract case is the unpublished Sod decision, but you may want to take a look. The appeals court forced a seller to complete the conveyance of a commercial property based on nothing more than an accepted offer. Moving on to subdivisions, Hart involved a project in Norwell where a homeowners association had been formed to provide for the use and maintenance of an access road. Now, the lot owners voted to allow certain neighbors to share the road, at which point the original developer objected. The land court held that he had no right, no standing to do so, given that he had already conveyed all of the subdivision parcels without reserving title to the road. He apparently was hoping to be able to charge those neighbors for the use of the road, but Judge Piper thwarted his plans. The subdivision control law forbids a local planning board from requiring a developer to dedicate any portion of a project to public use. Be that as it may, there have been situations where insisting on such a dedication has been considered a valid quid pro quo for allowing the developer to exceed otherwise applicable limitations on density. Now, in Montrose, a developer requested some relatively minor deviations from the Beverly Planning Board's regulations. For example, reducing the size of the manhole covers. In exchange for that, the Planning Board demanded that over half of the subdivision's buildable area be set aside as open space. You will not be shocked to learn that the land court considered this to be much too steep a price to pay. The Nantucket Planning Board was also guilty of overreaching in one Brock's court, where a developer requested an exemption from the subdivision control law because each of his proposed lots had adequate frontage on an existing public way. The board, however, refused to grant an ANR, approval not required endorsement, until the road was improved so as to conform to standards governing roadways in subdivisions for which planning board approval was acquired. This would, of course, defeat the whole purpose of the exemption, as the land court readily recognized. In Wild, a developer needed approval for the creation of this was a brand new 10-lot subdivision which clearly required planning board approval, so you would think that the Williamstown Planning Board had every right to apply its design and construction standards to a narrow gravel road which was to be used as a means of access to the project. But instead, the land court found that the board should have waived its regulations and allowed the use of the road in its existing condition. That's because existing neighborhood residents had been traveling over the road for some time, going back and forth to the center of town. They also used the road as a shortcut to get to the state of New York. And meanwhile, neither the town manager nor the police chief had any objection to granting a waiver. So it was unreasonable, arbitrary, and capricious for the planning board not to do so. Taunton versus O'Donnell is our only case on taxes and tax takings, but it's a real doozy, exposing a clever but unsuccessful charade by a delinquent taxpayer who had been defaulted when he failed to contest a proceeding by the city to foreclose its tax lien on its property. Judgment was entered 4 months later. a motion to vacate the judgment was denied because the taxpayer had failed to file a timely motion to remove the original default. The taxpayer, and I hasten to add that no attorney was involved in these shenanigans, then prepares a backdated motion to remove the default, which he photoshops in order to add a land court timestamp suggesting that the motion was filed within days after the default was entered. We're not done. He then sends a buddy to go to the clerk of the court and request a file for a totally different case where the bogus motion is surreptitiously placed. A few days later, another buddy requests the same file and says to the clerk, "Oh my God, look what I discovered. There's a motion here that was misfiled." Well, I'm happy to tell you that the court uncovered this plot with the assistance of an expert witness who belongs to the Association of Certified Fraud Examiners. Now, what a land we live in where we need an outfit like that. In any event, Judge Foster struck the motion and went so far as to prohibit any further filings without his advance permission. Our review of recent title cases begins with a couple of opinions on life estates. In Brennan, a house in Falmouth had been conveyed to a family trust subject to a life estate in favor of only 2 of 3 daughters. At some point in time, I guess the trustee got a guilty conscience and decided to give a life estate to the 3rd daughter as well. When the first 2 daughters complained, the land court decided that the additional life estate was valid, but it could take effect only when the trust's remainder interest ripened, which of course would be only when the first 2 daughters had died. In Freeman, a couple conveyed their Wenham house to their son. The issue was whether they had also created a life estate in favor of their daughter. Because the wording of the deed was ambiguous, a bankruptcy court judge explored the parties' probable intent. Now, given that they had purchased a separate home where their daughter could live, the conclusion was that the son's house was not meant to be encumbered by a life estate, which left him free to declare a homestead shortly before going belly up. Now, that's a good segue to a trio of other homestead cases. In Catton, a homestead had been declared with respect to a house where the owner operated an insurance agency on the ground floor and lived upstairs. As the bankruptcy court acknowledged, the point where a single-family dwelling with a self-contained commercial use becomes ineligible for homestead protection is not identified in the statute. Accordingly, a fact-intensive, case-by-case inquiry is necessary. In this particular instance, the residential portion of the house accounted for over 60% of its total interior square footage, so the insurance office was considered nothing more than incidental. The bankruptcy trustee's objection to the homestead exemption was overruled. It's been clear for many years that a homestead declaration is not legally classified as a conveyance, and therefore cannot be attacked as a fraudulent conveyance. In a similar vein, the bankruptcy court held in Dickey that a homestead declaration did not violate the terms of a court order which prohibited the transfer of a house. Chapter 188, which is the homestead law, affords a 1-year period during which the proceeds of a sale must be reinvested in a new house in order to preserve an existing homestead. In Williams, the bankruptcy court cited another section of the statute for the proposition that the homestead must be kept alive throughout the pendency of divorce proceedings between the couple, even after that 1-year deadline has passed. Fidelity National Title Insurance was very pleased with the city mortgage case, a policy which they issued to a lender mistakenly omitted an outstanding execution which had previously been recorded. The lender received notice that the property was about to be sold by a sheriff, but said nothing to the title company until after the sale was completed. A federal district court judge held that this delay was fatal, given the standard condition in all title insurance policies requiring prompt notice to the insurance company of any claim. Had Fidelity known of the pending sale in advance, it could have reduced its liability by satisfying the outstanding execution or simply acquiring the property itself. Kuhn was an 88-page opinion in which the land court decided that a beach was owned by the town of Marshfield pursuant to an adjudication by the SJC in the early 1830s. However, members of the public had no right to access that beach over roadways contained in a nearby subdivision. Even though the town had graciously plowed and maintained those streets and picked up the trash, there was no compelling legal theory permitting the court to conclude that those private ways had somehow been magically transformed into public streets. In Fordham, the land court was called upon to consider whether that portion of a driveway which extended onto a neighbor's property had to be removed as an improper encroachment. The answer was a resounding yes, since the encroachment was not only deliberate, it was also extensive. It encompassed nearly 600 square feet. The cost of removal would be less than $35,000, hardly a prohibitive sum, and there was plenty of space where the driveway could easily be relocated. We now have a few more nasty family disputes to tell you about. In McWilliam, a house in Foxborough was jointly owned by a mother and daughter who had acquired it from the grandmother. In 1992, when she was only 16, the daughter conveyed her interest to the mother. Now, being a minor, by law, she had a reasonable time to disaffirm the deed. The issue in this case was how long is reasonable. The land court allowed her to do so, even though she had waited 15 years. Now, there were a few extenuating circumstances at play, including chronic illness, drug and alcohol abuse, and entanglements with the law. In fact, Judge Long was convinced that the daughter had no memory of signing that deed and didn't learn what she had done until it came to light during a 2007 hearing when she sought a restraining order to keep her mother away from her son. In Perry, two women were beneficiaries of a nominee trust through which they held title to an Arlington house previously owned by their aunt. In order to facilitate a mortgage refinancing, there was a suspicion that banks nowadays don't like nominee trusts anymore. One of the women agreed to deed, and that's the key word, to deed her interest to the other, who later refused, after the mortgage had closed, to relinquish sole ownership and give the other woman back her share. The land court held that the deed is not a proper way to transfer a beneficial interest in a nominee trust. The proper vehicle is an assignment, but I don't want you to think that they exalted form over substance. More importantly, there was no intention that the grantor was supposed to be permanently deprived of her interest in the property. In Picarelli, a husband and wife owned two houses. This was their second marriage, and each had kids from the first marriage, and they agreed that the wife would convey her house to the husband's children, subject to reserving a life estate. When she reneged and went bankrupt, the children tried to convince the bankruptcy court to impose a constructive trust on the house for their benefit, but the judge refused. In his view, the wrong which they were trying to redress was nothing more than the enforcement of a contract to make a gift. Perhaps the worst transgression can be found in U.S. Bank, where a daughter relied on a power of attorney from her mother to grant a mortgage on the mother's house. On the very day when the power of attorney was allegedly granted, the mother was not only terminally ill and in hospice care, but she was also unconscious. Her signature had been forged, but even if it had been genuine, the power of attorney was of no use given that the poor old lady died before the closing. That leaves us with Schuster, where a restriction prohibited construction on some land in Mendon. When an abutter brought suit to enforce the restriction, the land court held that the complaint had to be dismissed because the abutter's property was not explicitly referenced as being the benefited land in the instrument which created the restriction. There was no mention, however, of a 2011 decision where the appeals court, at least in my view, came to a totally different conclusion, namely that restrictions, no matter how they're worded, can always be enforced by abutters. When you focus your attention on zoning exemptions, as we do now, it's safe to say that the devil is in the details. Section 3 of Chapter 40A is where you'll find most of these exemptions, but there are very subtle differences in the statutory language from case to case. For example, solar energy systems cannot be prohibited, but they may be reasonably regulated by a city or town. In Dessau, the land court suggested, denying a motion for summary judgment, that it might indeed be reasonable for the town of Hatfield to allow these kinds of facilities only within an industrial district. Now, much broader protection is given to child care centers, where the use may not be forbidden in any district. Only reasonable dimensional regulations can be imposed. In Walker, the town of Acton limited a proposed new child care center to 2,500 square feet, which translated into less than 2% of the total size of the lot. The rationale was to avoid tarnishing the residential complexion of the area, but the land court noted that the neighborhood already included several commercial uses, including an animal hospital. The local zoning board was instructed to allow a larger building. Chapter 40A allows cities and towns to classify non-conforming uses as having been abandoned where they are not actually used for a period of 2 years or more. Because the town of Wareham had not accepted that invitation, it was up to the land court in Cheraloosa to decide whether a non-conforming oceanfront house destroyed by Hurricane Bob in 1991 could now be rebuilt, and it was essentially a matter of common law. The previous owner had failed to avail himself of the right to reconstruct the house, allowing the land to lie vacant for decades, and that lot was eventually sold for the bargain basement price of $5,000, reflecting an assumption that the lot was no longer buildable. Well, that became a self-fulfilling prophecy when Judge Piper determined that the use had indeed been abandoned. Section 6 of Chapter 40A allows lawful non-conforming uses to be enlarged under various circumstances. The key word for purposes of today's digest is lawful. In Haley, a billboard illegally exceeded size limitations imposed by the Danvers zoning code from day one. So Section 6 could not be utilized as a way of making it even bigger. In Pyle, the issue was whether a non-conforming house on an undersized lot had been used for residential purposes prior to 1945, when the Manchester zoning code was initially adopted. There was a pre-1945 plan which identified the building as a greenhouse, no mention of a house, but an architect purporting to be an expert witness testified that the gardeners must have lived on site, as if this was Downton Abbey or something like that. There was absolutely no other evidence to support his conclusion, which Judge Long dismissed as nothing but speculation, gratuitously adding for good measure, and these are his words, not mine, I have many architect friends, not every architect knows everything. Our next section begins with a look at the Brennan case, where you wonder why somebody thought he had a chance of getting a special permit to operate a construction business from his residence, including the storage of trucks weighing up to 73,000 pounds. The Berlin zoning code prohibited the special permit from being granted unless the appeals board determined that the adverse effects of the proposed use would not outweigh its beneficial impact. Those adverse effects included the prospect of trucks mowing down joggers, kids, and other pedestrians on a narrow road with no sidewalks. The special permit was denied. In Fordham, on the other hand, the Weston zoning code was a lot more receptive to the notion of allowing vehicles, supplies, and other equipment to be stored on a residential lot in order to facilitate operation of the homeowner's landscaping and snow plowing business. A special permit could be issued so long as there was no exterior indication from the street that there had been any violation of the residential character of the neighborhood. The owner went to great lengths to install a dense barrier of trees and shrubs which were sufficient to hide the commercial equipment and satisfy the code. In response to the housing emergency created by the baby boom, I had never been aware of this, the Massachusetts legislature passed an emergency special act in the 1940s allowing cities and towns to grant variances permitting owners to add one additional apartment to their buildings. A Waltham landlord obtained such a variance way back then and proceeded to construct an extra apartment which would otherwise have been forbidden. The variance provided that the new unit could only be rented to veterans and that it would lapse after 7 years. When the property was purchased decades later, the new buyer discovered that the variance had expired, making the extra apartment illegal. No problem. Section 10 of Chapter 40A provides that use variances granted prior to January 1, 1976, but limited in time, can be extended. And in Campania, the land court interpreted that statute to apply even where the variance had previously expired. The court added that the appeals board will now have the inherent authority and indeed the obligation to modify the conditions of that variance if circumstances have changed. And Judge Foster went so far as to declare that the provision reserving the apartment for veterans was downright unenforceable. Drummy reminds us that the provisions of a local zoning code apply to land owned by the city or town itself, absent a clearly expressed exemption. The town of Falmouth will therefore need to obtain a special permit in order to construct a wind turbine. The appeals court held that an exemption for community service uses did not extend to windmills, which were subject to a separate, comprehensive, town-wide regulatory scheme. 1 year ago, I told you about the Green Mountain case, where a federal district court judge applied the Federal Telecommunications Act of 1996, which supersedes local zoning regulations and prohibits local appeals boards from blocking the construction of new towers which are needed to rectify a gap in wireless telephone service, better known as a dead zone. Now, the judge decided at the time that a proposed 140-foot tower was excessive. But he has now ruled that the town of Milton must grant whatever variance, special permit, or other approval may be necessary in order to allow the construction of a smaller tower not exceeding 120 feet in height. In Pandia, a group of plaintiffs wanted to challenge the issuance of a special permit for a new 92-room hotel in Lenox. One of the opponents was an outfit named Mahita Hospitality Group, which apparently held an option to purchase the adjoining parcel. It was argued that option holders have no right to contest a special permit, but the land court refused to construe the definition of an aggrieved party so narrowly. Now, of course, if Mahita's opposition, and you kind of sense this from the title, Mahita Hospitality Group, if their opposition is based on nothing more than a desire to suppress economic competition, remember that that is not a basis on which standing can be confirmed. In Palulo, the Natick Zoning Board granted a variance in order to preserve a house which had been illegally constructed. When a neighbor objected, the land court held that he had sufficient standing to pursue the appeal given that his bedroom was illuminated by headlights even when the shades were drawn whenever vehicles exited or entered the adjoining driveway at night. Now, on the merits, the court found that the variance was invalid. And of course, as we've said before, 95% of all variances granted in Massachusetts are invalid if anybody bothers to appeal them. But this was the key issue which was left open for further consideration. Would the illegal house need to be demolished? A similar situation was presented in Del Prete, one of those unofficial appeals court decisions we just skipped. And in my view, this definitely had sufficient precedential value that it should have been an official decision. The trial judge in that case was instructed by the appeals court to consider equitable alternatives to a tear-down order, particularly where the owner, as in Palulo, had relied in good faith on the issuance of a building permit. Monetary damages might be an alternative remedy, as the appeals court had suggested in an earlier decision 3 years ago. If you're wondering what the underlying illegality was in Palulo, the answer can be found in the case with the same name, which is indexed under the miscellaneous section of today's zoning digest. The depth of the lot needed to be at least 125 feet, and the local building inspector, trying ever so hard to be accommodating, measured the distance diagonally. And if you remember the theorem you all learned in geometry, the diagonal side of a triangle is, of course, its longest distance. Although the zoning board was willing to approve this methodology, the appeals court was not. 3 other new cases also address the issue of how to construe provisions contained in a local zoning code. In Epstein, the sale of firewood did not qualify as a permissible forestry use, given that the vast majority of the timber had been grown and cut off-site. In Newport Materials, an asphalt processing facility could not be considered light manufacturing where it utilized neither hand labor nor quiet machinery. Light manufacturing, as opposed to heavy manufacturing, is one where there's no constant thumping or percussion effect. But the land court indicated that the project would be permitted if sound attenuation barriers were installed. In Palmer, it was proposed that wood chips be burned in order to supply power to an electric generating plant. The Springfield zoning code prohibited commercial incineration, but the land court held that that provision was meant only to apply to the burning of ordinary trash and rubbish. A much larger utility plant, namely the Pilgrim Nuclear Power Station, was the focus of Bostek. Neighbors objected to the issuance of a building permit for a storage facility where spent nuclear fuel would be stored. And the issue before the land court was whether they had standing to proceed. Now, their concerns regarding health and safety were preempted by a comprehensive set of federal regulations. Their fear of environmental degradation, including thermal pollution, which threatened local wildlife, was shared with the entire community and did not affect these plaintiffs alone. So once again, you couldn't have standing on that basis. But the land court still refused to dismiss the complaint, however, because an additional claim that the project would diminish the value of the plaintiff's property fell within the scope of a Plymouth zoning code provision which expresses the goal of conserving the value of land and buildings in the town. 3 of today's cases involve jurisdiction, or more precisely, lack thereof. Chapter 40, Section 14A of the General Laws is designed to allow a declaratory judgment type action where somebody asks a court to decide whether a proposed development would violate the local zoning code. In Burke, the land court held that this statute may not be utilized when the project is nothing more than theoretical. A developer had planned to construct dormitory housing for students attending college in the town of Amherst, but the project had already been withdrawn in the face of serious community opposition, so there was really nothing left to sue about. In country places, the Middleton zoning code did not allow a building permit application to be filed until the planning board had made a preliminary determination that there would be adequate access to the locus from nearby streets. The land court analogized this to site plan approval, holding that the planning board's rejection of a proposed project could not be appealed until the developer had applied for a building permit and been turned down. In Skorsky, the appeals court upheld a decision to the effect, thank God, that housing court judges have no jurisdiction to hear appeals challenging the denial of a special permit for a so-called large-scale project. By statute, those cases are confined to the Superior Court and the Land Court permit session. In Foley Dupuis, 2 adjoining lots came under common ownership. That meant that they had merged and had to be treated as a single parcel for purposes of applying the provisions of the Barnstable zoning code. Unfortunately for the owner, the code allowed only one building to be constructed on a given lot, and because there was one there already, a second house could not be added. Now compare that to what happened in Pallets. 3 single-family homes were already located on the same lot in Tisbury. The owner took advantage of an exemption in the subdivision control law, which allowed him to divide that property into 3 separate lots, each with its own house. In doing so, however, he triggered a number of zoning code violations related to lot size, frontage, and setback. The SJC, no less, held that none of those new lots could be sold so as to be converted into separate ownership without a variance. A variance would also be required before any of those houses could be demolished and replaced with a larger structure. As Justice Cordy explained, and I quote, "The notion that a division of land would bestow immunity from zoning compliance simply because it was exempted from planning board oversight strikes us as abrasive to the independent character of these regulatory regimes." We're left with Showtime Entertainment, which comes to us by way of the U.S. Court of Appeals. The Menden zoning code imposed a slew of restrictions on a proposed adult entertainment complex where up to 244 customers would be able to watch live nude dancing while partaking of alcoholic beverages. Thanks to constitutional provisions which protect freedom of expression, even this kind of expression, any regulations enforced by the town, in the words of the court, would need to be uniquely precipitated by this particular type of entertainment. Limitations on the size of the facility and its hours of operation did not pass muster because there were already loads of large commercial establishments doing business along the same heavily traveled route, which I think was Route 16. The biggest issue by far was a section of the code which forbade the consumption of alcohol at an adult entertainment facility. The court didn't know how to handle that. They decided to punt, and they referred the question to the SJC for its advice. I do sincerely hope we all make it through whatever regulatory headaches lie ahead. I'm sorry if I sounded so pessimistic before, but do remember that the world needs both optimists and pessimists. It may be an optimist who gave us the airplane, but it was a pessimist who gave us the parachute. See you in November.
Thank you, Phil. Very good. How are you?
I love your columns every month.
Oh, thank you. I enjoy writing them.
Take care.